All right. Hello, everyone. Good morning. I'm Leonard French, your favorite copyright attorney. And I'm here this morning to talk about copyright law and other law and, well, just really anything you want to talk about, because that's just how it works. With me here in the studio remotely, thanks to the wonders of 2017, is Brandon Captain Yosho. Good morning, Brandon.
Hello.
So let's first get some feedback from all y'all. How is the sync? I didn't change anything, so sync should be a lot better. Let me just verify. Yep, got the same. Oh yeah, sorry about the video. That'll change in just a second. I'm running after my dogs, and that's actually pretty good for running, right? Like that's not bad for. The camera's doing pretty good there. Honestly, don't think the encoding is doing really great, but it stabilizes in just a moment, I promise. So sorry about that.
Yes, Christopher has noticed that I'm using a different microphone today.
So everyone say hi to the dogs. We went to the stream yesterday to get you some quality B-roll. Yeah, sorry about Chris. I meant to edit that out. I totally forgot to edit out that initial part. So yes, today we're going to go over a couple very interesting things. Robert Half, I have no idea who that is, has released a legal salary guide that I thought you all might find interesting. Yes, it is a stream. It is a crick. I agree, Dustin. Right now it's more of a stream, but if you look at the banks and you see how high that river gets on a regular basis, it's a pretty big stream at times. So we're going to talk about the legal salary guide. We're going to talk about the motion to strike that I filed in the Imagos versus Alex Mauer case. Bit rate, yeah. Sorry if InGen if the bit rate is a bit low for some of the detail, but we've had problems in the stream before with sync, so we're going to be keeping that going at the 3,500 kilobits per second that we've got going. I can try upping it at some point, but I'm not going to do it for this stream because we're already going. Anyway, so I filed a motion to strike in the Alex Mauer case this week, and we're going to go over the details of that and what I hope is the judge's response and what I think the chances of that are. And then we're going to go over the lawsuit that was filed by no less than 19, that's 19, no less than 19 of the states of the Union against no less than Donald Trump over the threat to halt subsidies to the Affordable Care Act. And we'll go over what that means, and they have a 28-page lawsuit that we will cover. So, before we get started, are there any complaints about the audio, the sync, me, Brandon, or anything in general that we need to cover before I get started? Brandon, let me know.
Just quickly want to let you guys know, we are still taking questions by form. The link is in the description, so if you do have any questions, go ahead and submit those, and we'll get those in for later on, okay?
Well, how do we like the music stream? Should I keep the music going, or would you prefer that I kill the music while we do the important things? Give me a little feedback. I'm getting the one of the links open here from Robert Half, so that we can go over the website too. Sounds great. It's good. Okay. Can't hear the... This happened last time, didn't it? I'll just mute the music. How about that? Music. That's freaking funny. Oh, I think I might know why. Hang on. That is funny. So here, let me first turn it up. I'll turn it up to 100%. Tell me if there's music. It might be outputting to a different audio device on my platform, on my system. I don't even know. Yes, there is music. Okay, then it was just turned down too low.
There seems to be an even 50-50 split on whether we should use music or not.
All right, then I'm gonna bring it down to next to nothing again.
Oh shoot!
Yes, music. Now please mute.
Leonard, did you change your hat?
Oh, I didn't.
Oh.
Also, I don't think anyone's noticed, so we'll just take that off there.
Yeah,
and we'll put this other one on.
You were looking off to the left, so hopefully nobody saw that.
Yes, our new hat says this. Please no step on snack.
There we go.
I have several patches. The last one had a curse word on it, and we were sharing that with Stream, and so maybe I'll just not make that the thing that's on my head for the entire actual live stream. So let's see. What is this? That is not anything. Why Firefox? Why do you do this to me? Hang on. Just bear with me for 1 second. That's not Firefox either. Gosh, there we go. All right. So here was something that was sent to me, and I realize that this is somebody's marketing thing and that they want you to give them your information to download their guide. And since they want to, do all of this, I'm assuming that their guide is copyrighted and that I'm not going to be able to share their guide, willy-nilly. So if you want a copy of what I'm about to go over, you can go to this link that's in the description and get a copy of this guide. Okay? So now, this is the guide. Like I said, I'm not going to go over it page by page. Instead, what I'm going to do is put the dog video up here, and I'll look through this real quick. I wanted to show you a couple of their graphs. This is the legal hiring trend guide from this group, Robert Half. I really didn't look into who he was. It looks like it's an investor or a job-seeking website, maybe. They're saying here that there was steady hiring activity in legal fields in 2017. One of the parts that I wanted to point out here was, this section here. 67% of lawyers said that it is challenging for their law firm or company to find skilled legal professionals today. So that's 2/3 of lawyers. So if you are looking for a job in the legal industry, whether you are a lawyer or not, there are incredible opportunities for you to get a really great job if you can overcome this challenge for your attorneys, your hiring manager, whoever you have to impress. Make it less challenging for them to find you, for them to identify your skills as a legal professional, identify your legal professional skills, and you can probably achieve some of these higher salaries and better paying jobs that are available. Scrolling a little further here, I know some of you are interested in the numbers. We're going to get to those. But this graph I thought was also interesting. There's a lot of demand for litigators, either litigators or litigation support, and general business or commercial law. This seems to be a growing field. It seems to be about, 50% of the legal jobs are in litigation and business or commercial law, and another 10% in real estate, another 7% in compliance. You may not be aware that there's a whole section of the legal industry devoted to understanding government regulations and international law and being compliant with them. Even copyright and internet law have a section of privacy where we have to write terms of service and privacy policies for companies, and those are a big deal sometimes. when your company is, say, Dropbox, or your company is DoubleClick, and they are collecting people's information, or your company is Equifax, and they're collecting people's information. So those are good opportunities for people. I'm not going to take too much more time on this. Levels of job satisfaction. It turns out that the legal industry does have a decent level of on-the-job happiness and on-the-job interest in their work. However, they're not too great at having low stress levels. We've known this for years. Lawyers and doctors and other high-level jobs like that, usually the people have a almost double rate of alcoholism, drug abuse, suicide, depression, anxiety than other averages in the workforce. And I can vouch for that. It is definitely a very challenging profession. So here we go. You were talking. Everybody wants to see salaries, and some of these are as high as you would expect, and some of these are lower than you would expect. So salaries at a law firm for a first-year associate, 50th percentile, are $68,000. So that's actually not a ton of money. That's pretty much a starting salary for an electrical engineer. I'm not too familiar with a whole bunch of other jobs, but I'm sure that there are lots of other jobs that are almost as well paid as a first-year attorney out of law school on the average. If you are in the top 25%, you might make $85,000 your first year. And if you are in the top 5%, you might break $120,000. So the top 10% are your people who get $100,000 their first year. If you are successful as an associate at the firm, you can see that your salary quickly goes up, and by 10 years experience, you're making above $100,000, even if you're in the lowest 25%. So there's still good jobs to go into, but they're not good jobs to go into and fail at. You need to go into the job and succeed at the job. Otherwise, you owe a lot in student loans, or you might not be making nearly as much money as somebody who got an engineering degree, or a nursing degree, or a medical degree, or frankly, even construction and police and what we used to consider blue-collar jobs are sometimes even better paid than the white-collar jobs these days because, frankly, so many white-collar people don't want to do the blue-collar jobs that the blue-collar jobs have become more valuable. So corporate in-house counsel, you can see some of the numbers there. The in-house counsel makes a little bit less, but their jobs are also a little more secure. And then when you make it up to the general counsel level for a major corporation, your salaries can actually be a little bit higher. For your administrators and legal support staff and specialists, you can see some of the salaries here. Remember, your green column is your 50th percentile. So it is lucrative to be a legal administrator, a paralegal manager, a mid-level paralegal, even a starting paralegal with 2 to 3 years experience is making $40,000 to $50,000 on average. So if you've noticed that a lot of these numbers are pretty low for new lawyers with large student loans, you are correct. And it is scary. These numbers were even lower. When I went to law school and the 2008 stock market crash happened, that 25th percent number for that first year associate was about $30,000 to $38,000. And I wasn't even in the running. I didn't have the grades or the consistency to really be a candidate for someone who was looking for, like I said before, that level of stability, professionalism, and understanding of the law, as I was really going to law school as a reaction to some problems I was having in the corporate world as an electrical engineer. I don't even have an electrical engineering degree, and I was working my way into an electrical engineering position, and I finally got recognized, or finally got work that was at that level, but then the company refused to pay me or recognize me at all. And so I started looking into my legal rights and stuff, and realized that I was actually kind of interested in the courtroom, and realized that I could kind of get out of the situation I was in by going to law school. Don't ever do that. Don't ever do that. That was a bad decision. It led to some good things, but geez, that was the wrong way to do that. There are so many better ways, if you're in a bad situation, to get out of it than to take out hundreds of thousands of dollars in student loans and switch professions when you're not 100% sure what you want to do. So don't do that, but it does work out if you persevere. That's actually probably the big lesson here, is perseverance. But yeah, some of these numbers are fairly low for attorneys that have to contend with the competition of 2017 and need to pay back student loans that, frankly, are not at the lowest rates and are not often that easy to pay back when you're only making $50,000 a year, and you have to pay for other debts that you may have incurred from law school, etc. Okay, I'll stop. Legal support staff continued. Legal secretaries, administrative assistants are still in the $40,000 to $50,000 range. If you are an attorney and you're looking to hire, you can use these numbers to help figure out what you should offer or pay. And so they actually have a really awesome chart down here at the end, local market variances. I highly recommend that you check these out too for where you live. So like Boulder, Colorado, you can add 17.5% to those numbers. District of Columbia, DC, you can add 33%. So where are the expensive legal markets? Mobile, Alabama, Phoenix, Arizona, Oakland, California, San Jose, California, well, basically anywhere in California. San Francisco, plus 40%. Woodbridge, New Jersey, plus 26%. New York, plus 40.5%. Meanwhile, Philadelphia, Pennsylvania, which is my market, is 15 plus 15%, but I'm not there. I'm in Allentown. That's not even listed. Harrisburg is minus 5%. So you can get a really good idea of what's going on with jobs, prices, and your actual local market. There seemed to be some information here about the Canadian market as well. Even more Canadians find it challenging to find skilled legal professionals. And they are also almost 59% of Canadian lawyers said that they need help with business and corporate law and litigation. So trying to stop short of committing copyright infringement, I'm going to stop reviewing that there. If you are interested in that, go ahead and download that PDF from that website. I think that is very, very interesting, and I hope that wasn't too boring to go over for some of you. I understand. I understand why that would not be the most interesting thing, legal salaries. Okay. So let's go over something possibly a little bit more interesting. Chris, thank you for the 10 British pounds, I think that is. Love listening to these while working on my electrical engineering PhD. Thanks for keeping me sane. Oh, Chris, please stay tuned because we're only going to be doing more and more engineering stuff. You may not... the rest of that story is that a lot of my loves and passions are going to come out now that I have a little more freedom, a little bit more time. And so I've already ordered a Hack RF, a 1 megahertz to 6 gigahertz. Is it 1 megahertz or 1 gigahertz? I think it's 1 gigahertz to 6 gigahertz software-defined radio. I'm an amateur radio operator. I'm very, very interested in all sorts of communications, information systems included, and this stuff is just really my passion. So I've already got an SDR dongle, and it's not powerful enough. It can't pull in signals, and it certainly can't go up to 5.8 gigahertz and see what the airwaves look like when we hit Wi-Fi frequencies at 2.4. So, yes, KB3DEM 73s here to everyone. I really, I'm going to be getting back into that now that I have a little bit more time. I've been disappointed that there hasn't been more activity on the airwaves, but then again, I'm stuck as a technician on UHF and VHF. So anyway, I'll stop talking about that now because I'm sure that 2/3 of the stream really has no idea what I'm talking about. So this is my motion to strike, the answer of Alex Maurer, and or a motion for contempt. So if you remember, Alex filed a late pleading. I had filed for default on September 26th, the day after her response was due. And when I forwarded our response, our entry of default to her, we then got some kind of responsive pleading 3+ hours later, about 3 hours later. Tactical Bra gives Canadian $5 and wants me to say dongle again.
Oh, Lord.
Thank you, Bra. And so I took some time. First off, the Las Vegas thing happened in the middle of this. That really it's hard to work on stuff when that's happening. And I took some time to work on our response. I wasn't exactly sure whether we should accept her answer and then try to make a motion for judgment on the pleadings. But that skips a few steps. If I make a motion for judgment on the pleadings, I kind of skip ability to file a motion to dismiss. And if I file a motion to dismiss, I kind of skip the ability to file a motion to strike. So I figured I'd start with a motion to strike. A few of you attorneys out there had also made some suggestions along this line, and it seemed to be a consistent suggestion. So this was ultimately what I came up with, was to file a motion to strike and to include a motion for contempt. And you'll see what I did here. Plaintiff hereby requests the court strike defendant Alex Maurer's answer on the grounds that defendant has failed to file a timely response. Defendant had actual notice and meaningful participation with the court. Defendant's untimely response should be struck and a default entered by the clerk. Now, you may have already heard all of this from Sid Alpha, so I'm not going to read every line. Also, some of this is just a repeat. What I'm adding here is that defendant has failed to file or serve a timely answer or response, or to request an extension of time, or to otherwise plead or defend in a timely fashion. I go over the details of when things were filed, and I go over that we're requesting that the defendant's answer be struck, a default be entered, and if that's not possible, that we move on to a contempt proceeding and try to do the same thing. I prepared an order. It's a very simple order. This is possibly going to be signed by the judge. Upon motion by plaintiffs and it appearing that defendant has failed to file or has filed an untimely answer, it is hereby ordered that the clerk enter a default and the clerk strike defendant's answer. And then I left a third line blank in case the judge wants to write something in, and then there's a signature line for the judge to sign. Oftentimes judges don't sign these things that way, but hey, sometimes you get one right. Nope, that's not it. Let's get back here. Thank you. Sorry. So this, then, is my memorandum in support. Here, we'll zoom in there. Plaintiffs filed this action as a last resort. Defendant had ceased performance of her contract for plaintiffs and then began claiming ownership to plaintiff's project, a video game. Don Thacker spent months trying to privately resolve the matter with defendant, yet defendant persisted in making very deliberate public claims regarding ownership of plaintiff's video game. I go over that we filed and served our complaint. We filed a motion for a temporary restraining order. Defendant has filed an untimely response. Plaintiffs have had no contact nor received any correspondence from defendant regarding her attorney or her response until 3 hours after serving defendant with plaintiff's request for entry of default on the 26th. Even then, we only received a copy of correspondence with the court's clerk informing defendant that she must sign and serve her pleading. It wasn't until September 27th at 4:50 p.m. that the defendant finally sent an email to plaintiff's counsel with the signed response. Defendant's answer is a one-page, single-spaced document that does not explain the delay in filing or the lack of defense counsel. And we did go over that document on the last stream or the last one of my previous videos, I think. So if you want to see that in more detail, please go there. I'm not going to read it again here. It's fairly quick to go through over there. My stepfather says I have to send ham money. Thank you so much, Avery Sados. Correct me if I've mispronounced that. Defendant has failed to show good cause. So Federal Rule of Civil Procedure 6 is about timing, and it says, Part B says that when an act may or must be done, the court may, for good cause, extend the time. And that must be with or without motion before the original time has expired, or on motion after the time has expired, only if the party has failed to act because of excusable neglect. Well, defendant here has made no such request nor shown any good cause. Defendant had over 60 days to find a replacement attorney and respond, and she failed to file any request to extend the time or show good cause for such an extension. If a moving party does not seek an extension until after the time limit has expired, the court may exercise its discretion only if a motion is made and the moving party proves its failure to comply with the deadline was the result of excusable neglect. Now, I think they're meaning that the defendant needs to make a motion, but even then, I've still also made a motion. Whether an act qualifies as excusable neglect depends on three factors: the danger of prejudice to the opponent, the length of the delay, including whether it was reasonable, and whether the movant acted in good faith. And there, I believe they are referring to the movant as the defendant, the person who skipped the deadline and is now moving to have that deadline extended. There is ongoing prejudice and damage to plaintiff, a sincere claimant in genuine need of prompt relief. Development of their video game is currently halted while this action clears up ownership of plaintiff's copyrights. I refer to the affidavit of Don Thacker. The longer this action takes, the later the project development and release schedule, resulting in higher costs and lost sales. The length of the delay is great. After being served with a summons and complaint in the beginning of July, and after hiring then firing a respected attorney to represent her, defendant did request additional time to prepare and complete a meritorious response. The court generously gave defendant until August 21st, 33 days, to find an attorney, and until September 25th, an additional 35 days, to file her response. Not only did defendant fail to timely file a response, she also failed to request an extension of time or explain the delay. She has not acted in good faith. Defendant has failed to explain her delay or request court permission. Plaintiff believes that defendant is acting out of disrespect for plaintiffs and the court and with the intention of driving up the cost of litigation and increasing the delay for plaintiffs to move on. So now I cite a case, Yellow Book Sales and Distribution v. White. It is a Eastern District of PA case from 2011, so this would be precedential. It should be academic and precedential. This court held that a defendant had failed to show good cause for a 4-week delay where defendant's response made no showing of good cause. The court recognized that defendant's delay constituted a proper basis for an entry of default. FRCP 55A requires the clerk to enter a default upon motion and affidavit of the plaintiff. Marauder 1024, thank you for the $10. 73s to you as well. Defendant here had appeared and meaningfully participated in the court's hearing on July 13th and July 19th. And yes, I make a typo here, but I think it's inconsequential and the judge will understand. Defendant fired her attorney after the first hearing and requested time for the court to find new representation and respond. Despite being present and despite helping set her own deadlines, she still did not prepare and file anything with the court until 3 hours after plaintiffs requested and served its entry of default. Plaintiffs speculate that, had it not been for their proper service of their request for default, defendant may not have responded at all. Despite having meaningful face-to-face interaction with the court, defendant was unable to comply even with the relaxed response schedule ordered by the court. Plaintiffs respectfully submit that a strike is a narrowly tailored remedy that can directly address the issue. By requiring defendant to open the default, the court preserves its authority, deters defendant and others from failing to communicate with the court on the matter, grants relief to plaintiffs who have acted in good faith, and requires defendant to show good cause if she intends to challenge the default. Why is that important? I don't want to give Alex any help here, so I'm just going to say that she must show good cause in order to undo the default. I'm not going to explain the procedure by which she would do that. I will explain that after we win the case. In the alternative, a motion for contempt and sanctions. Defendant has failed to obey a court order and should be held to show cause why sanctions should not issue. Plaintiff submits the sanction of a strike and default as a narrowly tailored remedy. Briefly. And I mean really briefly. I kept this as brief as I could. I did not think I needed to annoy the court with telling the court about their own contempt powers. The court's inherent contempt powers are broad, and I cite a case from 1873. The moment the courts of the United States were called into existence and invested with jurisdiction over any subject, they became possessed with this contempt power. Defendant has violated the court's July 19th order requiring her to obtain an attorney and respond by September 25th. If the court is unable to strike defendant's answer, then plaintiff requests that the court hold defendant in criminal contempt of court with a remedy of striking her answer and entering default. And I guess that was another typo. I should have said as mentioned above. The criminal contempt standard is appropriate whenever claims or defenses are extinguished by a sanction or remedy. So I really wanted to use a civil contempt standard here, but the civil contempt standard allows her an opportunity to cure, and I want to make sure there's no opportunity for her to respond here. Under Title 18 U.S.C. Section 401, a court of the United States shall have the power to punish by fine or imprisonment at its discretion such contempt of its authority as disobedience to a lawful writ process order, etc. So yes, it does say fine or imprisonment, so I'm not 100% sure that a strike is a remedy under that section, but either way, I wanted to cite what the authority is or what the source of the court's contempt power was. Criminal contempt requires the court to hold a hearing where a defendant may show cause why they should not be held in contempt, and I cite the Federal Rules of Criminal Procedure there. Also, Federal Rule of Civil Procedure 11 provides sanctions for signing and providing and presenting a paper to the court for a improper purpose, where the defense claims or defenses are not warranted by existing or non-frivolous extension of law, where the factual contentions have evidentiary support, or where denials of factual contentions are warranted by evidence. If you do those things, if you sign a paper and turn it in and things are presented for an improper purpose or against facts, then you might be subject to sanctions upon motion later. And those sanctions could also have things like striking a paper, or could also have consequences like striking a paper or a fine, or I don't know about imprisonment for Rule 11 sanctions, but it definitely could lead to something. So that then I finish by asking the court to do what I've been asking the court to do. I also filed an affidavit just saying in my own words and signed under my own name that these things did happen as I said they did. And then here is what I provided to the court as my evidence of this late filing. You can see here that on September 26th at 3:50 p.m. Eastern Daylight Time, which is our summer time here, this response to the complaint by Leonard French, sorry if it is a little bit late. So there's no explanation there, which is one problem. There's no showing of good cause. And then she writes back that the rules of civil procedure require you to attach a certificate of service and sign the thing. And so she writes back, here's the updated version of the response. This came in at 4:50 p.m. on September 27th. It looks like she was emailing with the clerk on Wednesday morning at 9:40 and didn't send the actual signed response until 4:50 p.m. So although this is technically late, it's not that late if you only consider the September 25th deadline. But when you consider that we served her in July and she's had 3 months to write up what is essentially this one-page lackluster response, I don't think so. I don't think that that's enough. I think the court will strike it. I'm not 100% sure that everything will go our way, but we'll see what the judge wants to do when the judge gets to reviewing our filings and making his decision and issuing it. I know that we'd all like to see a decision be issued as soon as possible. I've even been checking my phone twice as often as I usually do, hoping for that email to come through. All I can say is we have to wait patiently. I wish I could accelerate things for my client and for our community, but I can only do so much, and now we just have to wait for the judge to decide. If the judge allows Alex's pleading to be admitted to the record as a valid answer, then I will have to answer it with like a motion to dismiss or motion for judgment on the pleadings. Or we could enter discovery. I could depose her, request evidence, and then upon getting or not getting those things, I could make the appropriate motion for summary judgment. So we'll see. It's just a matter of time at this point. I don't even think it's a matter of needing to gather more facts or anything. I think it's really just a matter of time, and we just have to wait for the long, slow arm of the law to come around and smack our defendant metaphorically in the legal face. So, that said, I came across a very, very, very interesting lawsuit that I want to share with you. Before I do, though, I just realized I didn't ask for questions. Brandon or anyone else, would you like to ask any questions now before I begin about the lawsuit? Is anyone there? We have lost Brandon. Or, yes, Brandon, you have been accidentally moved to the idle lounge. Maybe I'll bring you back by force. I've brought you back by force, but you're still muted, so. I do check my email. Unfortunately, it's not something that I generally do on stream. Things should be sent to Brandon, and Brandon parses them and triages them for me on stream.
Yep.
So, okay. Hearing no long question. Can Alex be criminally prosecuted for this? Yes, there is something in the copyright law for criminally prosecuting, and I have asked people to fill out the form for reporting her to the FBI's Cybercrimes Division, and we'll see if anything like that happens. I have my doubts. I don't know that prosecutors are looking at this case as a great example of DMCA abuse. Or maybe they are. Maybe it is a great example of DMCA abuse, and prosecutors just aren't looking at DMCA abuse as something that would be worthy of prosecution. So we'll see. I am going to move on to the next story, and I'm going to take my chances with its politically charged nature. But I think this is a very interesting thing to talk about, and I really, really want to cover this. Now, I have not read this yet, so we're going to fumble through this together. But let's just see who is involved here. In the United States District Court for the Northern District of California, filed by the states of California, Connecticut, Delaware, D.C., Illinois, Iowa, Kentucky, Maryland, Massachusetts, Minnesota, New Mexico, New York, North Carolina, Oregon, Pennsylvania, Rhode Island, Vermont, Virginia, and the state of Washington, versus Donald Trump, President of the United States, Eric Hargan, Acting Secretary of the United States Department of Health and Human Services, the U.S. Department of Health and Human Services, Steve Mnuchin, Secretary of the United States Department of the Treasury, the United States Department of the Treasury, and John Doe's 1 to 20. And there are a lot of attorneys. There are so many attorneys. Okay. Introduction. The states, I'm not going to read them all, bring this action to protect themselves and their residents from the unlawful actions of the President and the Secretaries of the Treasury and Health and Human Services, and other federal officials responsible for implementing the Patient Protection and Affordable Care Act, the ACA. Is a landmark law that made affordable health insurance coverage available to over 20 million Americans, many for the first time, and brought the number of uninsured Americans to a historic low. To achieve its goals, the ACA created local health markets called exchanges, both state-run and federally run, that offer health insurance options to consumers. The ACA also creates subsidies to make premiums and out-of-pocket expenses more affordable in these markets. So if you aren't familiar with those words, if you aren't a person who has had to study a reasonable amount of insurance in order to understand what the hell you're buying, subsidies and premiums and out-of-pocket expenses and markets, I'll take a second. So health insurance is a very strange thing. It's much easier to think of car insurance first. People drive cars, they more or less voluntarily drive cars, and people are people. They bump into stuff. They might bump into things and have minor collisions. They might bump into stuff and have major accidents, collisions. People might die. People's entire lives might be upended. My father was hit by a drunk driver. It was never the same after that. We used to go skiing. We used to do physical stuff. He could never do that anymore. He limps around when he walks. He's had both of his knees, I think one or both of his hips, and both of his wrists replaced, or surgery and all that, because the drunk driver made it so that he couldn't walk, and so one leg failed, and then the other leg failed, and then one hip failed, and the other hip failed, and then he was using his hands to get up and down. So it's important to have insurance to cover when you screw up as far as a car, or when an accident happens and you just genuinely something happened, or in the case of health insurance, when you get sick. None of us want to get sick. None of us intend to get sick, and all of us would love if we just went through our whole lives not ever getting sick. But we don't have control over certain things, and if you subscribe to the virtue or ideology that you shouldn't let humans suffer more than necessary, especially given the abundance that we have in the world. I'm getting dangerously close to politics, but everybody should have insurance, and everybody should be able to go to the doctor, and no one should have to sit at home wondering if they're going to die, or wondering if that pain in their chest is a heart attack, or if it's just, gas, and they're just gonna, fart it out. And then instead they go to the doctor because they don't know and they're scared, and then they end up with a huge bill and it turned out to be gas. Or they stay at home and it turned out to be a heart attack, and now it's the ambulance, and the ambulance has a bill, and the hospital emergency room has a bill, instead of going to see a cardiologist ahead of time. So there are reasons why you would want everybody to have insurance. So to make premiums more affordable, premiums are the costs of insurance. Why they just don't say the costs of insurance, I don't know. They call them insurance premiums. They make it sound like it's a good thing that you're paying this buttload of money just in the hopes that you stay healthy, or that someone can make you healthy. Anyway, so premiums are the costs of health insurance, and out-of-pocket expenses are the things that you pay for that the insurance company does not. Because even though you're paying $500 or $1,000 or more dollars a month, sometimes per person, the premiums do not cover everything, and you still have to pay a little bit for your doctor's visit, called a copay, or you have to pay a little bit for your prescription medications, or these things are called out-of-pocket expenses. So the Affordable Care Act created subsidies to make premiums and out-of-pocket expenses more affordable in the insurance market. Well, what are subsidies? Subsidies is money from the government or money from a third party that pays for your stuff. You guys, your Patreons, I have 400 Patreons who are helping to subsidize my life, to make my life much more easier and stable so I can focus on making these videos for you, because making a video like this doesn't, money doesn't come out of the camera, money doesn't arrive in the mail all by itself. Ads have to be run by YouTube, and that has to accumulate, and enough of you have to watch. And so the Patreon patrons and other supporters send money directly subsidizing my ability to make this channel. So the ACA, the Affordable Care Act, sends money to state insurance exchanges to lower premiums and out-of-pocket expenses for some people. If you are below 250% of the poverty level, you'll qualify for some of these subsidies, and your $600 or $1,200 a month health insurance will be paid partially by the government. And if it turns out that you made more money that year than you were supposed to, than you thought you would, and you don't qualify for the subsidy, then guess what? You owe it back. So it's a big deal. And these insurance premiums are going up by 10 to 20 to 30 to 40% per year, which means they're doubling in 2 or 3 years, which means trying to keep these things affordable is very important. So this case involves a central feature of those markets, federal cost-sharing reduction subsidies, called CSRs. Excuse me. CSRs make health insurance more affordable for low and middle income Americans by reducing out-of-pocket costs such as deductibles, copays, similar expenses. Under the CSR provisions, insurance companies pay upfront a portion of covered patients' out-of-pocket expenses with a promise that the insurance company will be reimbursed for these costs by the federal government. CSR subsidies are backed by a mandatory payment provision. The ACA requires the Secretaries of Health and Human Services and the Treasury to make periodic and timely payments to insure insurance companies, directly to insurance companies that are equal to the value of the reductions. It also provides a permanent appropriation that authorizes the secretaries to reimburse insurers for CSR costs without appropriations from Congress. The ACA's permanent appropriation is essential to the Act's proper functioning. Without it, insurers and state regulators alike lack the stability, predictability, and basic fairness and rationality necessary to maintain functional health insurance markets. Further, it ensures that beneficiaries have access to health care. Since insurers began offering health insurance plans through the exchanges in January of 2014, the secretaries have made CSR reimbursement payments each month under the authority provided to them by the permanent appropriation. On October 12th, with only minimal explanation, the president announced that his administration was reversing course. In a curt written statement issued by the White House press secretary, the administration stated that the DHHS had concluded that the ACA's permanent appropriation does not apply to the CSR payments. On the morning of the 13th, the DOJ made a court filing, including a copy of a new opinion by the Attorney General addressing the purported legal basis for the administration's actions. Early that same morning, the president tweeted, "The Democrats' Obamacare is imploding. Massive subsidy payments to their pet insurance companies has stopped. Dems should call me to fix." And I think we do have a copy of that notice. Let me pull up that notice real quick, because I didn't realize what it was at first. And now I know. This is the notice. This notice, the executive branch submits this notice to inform the court that the DHHS has directed that cost-sharing reduction payments be stopped because it has determined that those payments are not funded by the permanent appropriation for refunding internal revenue collections or by any other appropriation. The upcoming October 18th payment will thus not occur. That's Tuesday, guys. The executive branch will confer with the other parties, Wednesday, will confer with the other parties about this development and propose that the parties make submissions to govern proceedings by the time of the status update previously scheduled for October 30th. So this looks like it might actually be a document in a larger case. I don't know what case this is. We might have to look that up for a longer video. So, the administration's new refusal to make the required federal payments directly subverts the ACA and will injure the plaintiff states, their residents, and the entire healthcare system. The loss of funds and financial uncertainty caused by their actions will lead to higher health insurance costs for consumers and to insurers abandoning the individual health insurance market. The number of uninsured Americans will increase once again, hurting vulnerable individuals and directly burdening the states. The unlawful refusal to make CSR reimbursement payments will also substantially complicate the state's efforts to administer their healthcare markets, and in some instances leaves consumers with no health plan access despite their federal entitlements under the ACA. Indeed, across the nation, there are 1,472 counties with only one insurer. The administration's refusal to make CSR reimbursement payments will cause some insurers to pull out of the market, leaving many counties vulnerable and without health insurance coverage at all. Accordingly, the plaintiff seeks declaratory and injunctive relief to compel the President and DHHS and Treasury Secretaries to make the reimbursement payments. I'll skip all of the parties because it's going to be a lot. I will stop briefly to say I am proud of my state of Pennsylvania for joining this fight. I have been a recipient, and who knows, soon I might not be able to be anymore. I have been a recipient of these subsidies under the ACA, and my health insurance is much more affordable thanks to it. So this directly affects me, and frankly, if this goes through, my health insurance will jump a lot by hundreds of dollars, and that just, I'm not threatening anything here, but that just means that I've got to make that money some way and not focus. I can't, focus on. That's more money I have to make doing something. So I either take it out of the Patreon money or I have to take more cases and I do less. It's just complicating everything. People need levels of stability in order to function. And screwing around with their ability to function is not something that I think our government should be doing on a daily to weekly basis. Allegations. The ACA requires and authorizes the federal government to reimburse insurers for cost-sharing reductions provided to qualified individuals. Congress enacted the ACA to increase the number of Americans covered by health insurance and to decrease the cost of health care. In order to achieve these goals, the ACA adopted a series of interlocking reforms that including the creation of an exchange in each state, a marketplace that allows people to compare and purchase insurance plans. To make health insurance more affordable for low and moderate income individuals, the ACA provides for billions of dollars in federal funding. These subsidies help offset the two kinds of costs that consumers must pay in order to obtain health insurance: premiums and out-of-pocket expenses such as copays and deductible. The latter is known as cost sharing. Section 1401 of the Act provides tax credits that reduce monthly insurance premiums for individuals who earn between 100% and 400% of the federal poverty level. In 2017, between $26,600 and $98,400 for a family of four, and who satisfy additional criteria. The vast majority of individuals who buy insurance through the exchanges rely on premium tax credits to lower the cost of insurance. Section 1402 of the Act requires insurers to cover at least some portion of the cost-sharing expenses for individuals who are eligible to receive tax credits and whose household income is less than 250% of the poverty level. In 2017, $61,500 for a family of four. So what they're saying there is that you'd be eligible to receive a credit to help you pay for your health insurance, and this credit goes directly to the insurer. You don't actually get like a check or anything. If your family of 4, so 2 parents and 2 children, makes less than $61,500 a year, you're going to be getting a little help with your insurance. An insurance that wants to offer a plan through the exchange must offer at least one silver plan that reduces cost-sharing expenses for eligible individuals. I'm currently on a silver plan. The ACA requires the secretaries, I'm just going to say the secretaries, to pay both of these subsidies directly to insurers. It's law. For each individual who is eligible to receive a premium tax credit, the secretary must make advance payments to the insurer in the amount of the tax credit on a monthly basis. For each individual eligible to receive cost-sharing reductions, the Act similarly provides the secretary shall make periodic and timely payments to the insurer equal to the value of these cost-sharing reductions. These payments are made through a single integrated program created by the ACA. Under that program, the Secretary of the Treasury must make advance payments. To fund this integrated system of health insurance subsidies, the Act amended 31 U.S.C. 1324 provides a permanent appropriation. By amending that Act, or by amending that section, the ACA created a permanent appropriation for both the tax credits and the subsidies. As a result, the executive branch has both the authority and the obligation to make the payments to insurers on a regular basis. No further appropriation from Congress is required. I'm going to pause here for a second and just look up something, because there is a section that says what the President of the United States, like what is the enumerated power of the President in the Constitution. Let's see, he has the veto power, and we know that the veto power is not a line item veto power, right? That was Clinton was barred from that by the Supreme Court in the 90s, right? Executive orders, authority to issue proclamations and executive orders. A proclamation is the president's official announcement that he's taking an action. An executive order, which has the force and effect of law for carrying out a provision of the Constitution, statute, or treaty. The Constitution does not expressly give the president the power to promulgate executive orders. This power has been affirmed by the president's obligation to faithfully execute the laws. That's what I was looking for there. Faithfully execute the laws. What? Yeah, that's, wow. Every word, huh? Every single word in this sentence is a link. That's just, we'll just look this up. Article 2. That's not how you spell that. I do solemnly swear that I will faithfully execute the office of the President. He shall take care that the laws be faithfully executed. So I imagine we're going to see things in here about whether or not this is a faithful execution of the laws. After making CSR payments on a monthly basis, they have now determined that they lack authority to make them. So this seems like an interesting argument. Since the exchanges began operating in 2014, both Obama and Trump administrations have been reimbursing insurers. These payments have created substantial reliance interests. Residents who are eligible for CSRs have relied on them. Insurers have relied on them. The states have relied on them. Like the predecessors in the Obama administration, the secretaries and Trump have reimbursed insurers since taking office, and they have done so on the authority granted to them. However, they've now announced that it's no longer making payments. Based on guidance from the Department of Justice, the DHHS has concluded that there is no appropriation for the reduction for the cost-sharing reduction payments. In light of this analysis, the government cannot lawfully make the cost-sharing reduction payments. They also stated in a press release, after a thorough legal review and an opinion from the Attorney General, we believe that Congress has not appropriated money for CSRs, and we will discontinue these payments immediately. The decision to stop making CSR payments is part of an effort to explode the ACA. The administration's decision to stop funding CSR payments is not based on a good faith reading of the statute. Instead, it is in part a deliberate strategy to undermine the ACA's provision for making healthcare affordable and accessible. Since taking office, the Trump administration has engaged in a sustained effort to explode the ACA by making it more difficult and expensive for individuals to procure health insurance through the Act's exchanges. His first act of president included signing the executive order. Among other actions, the president has repeatedly threatened to stop making CSR payments at a moment's notice. These statements have created substantial market uncertainty. As a result, some insurers, unsure of whether the administration will continue making required payments, have decided not to offer plans through exchanges in 2018 at all. Others have indicated that they will raise premiums by as much as 23% during 2018 to guard against the risk that they will not be reimbursed for these required expenditures. Both of these predictable responses will make health insurance costlier and more difficult to obtain. The president's recent executive order is also aimed at weakening the exchanges. That order, among many other policies that are in conflict with the ACA, directs the administration to expand access to association health plans. These plans do not require the essential health benefits, which could leave people without access to mental health or substance use disorder treatment and fewer patient protections, allowing cherry-picking of healthy enrollees over the sick than to those provided under the ACA. By doing this, the president hopes to lure healthy individuals out of the exchanges. That would leave the sick as the only population receiving insurance through the exchanges, which would make insurance plans offered there costlier if insurance companies do not abandon the market altogether. That in turn could destabilize the market and create the very death spirals that the ACA was intended to prevent. The administration has also substantially reduced its efforts to educate and encourage individuals to sign up for health insurance through the exchanges. The Department of Health and Human Services slashed its advertising budget for this purpose to $10 million, a 90% decrease from the $100 million allocated for this program in 2016. The department also reduced the amount of money granted to nonprofit organizations that serve as navigators to help individuals enroll in plans that offer exchanges through the exchanges to $36 million from $63 million. That sounds like an awfully small amount of money. $100 million was allocated for advertising the whole system. I think I've heard numbers that the president has spent more traveling on vacation, like spent more taxpayer money traveling on vacation. In addition, the Department of Health and Human Services produced nearly 20 testimonial videos featuring individuals discussing how the ACA has harmed them. These videos subvert the law and were produced at taxpayer expense. HHS has also cut in half the enrollment period during which individuals can sign up for health insurance exchanges. Last year, individuals had 12 weeks to sign up. This year, they only have 6. Underscoring this administration's efforts to sabotage the ACA, the HHS announced that it will shut down healthcare.gov, the website through which consumers may enroll in coverage through the exchanges, for nearly 12 hours every Sunday during the enrollment period, which makes signing up for health insurance more difficult. Furthermore, the Internal Revenue Service suspended enforcement of a rule designed to encourage individuals to sign up for health insurance. At the beginning of the year, the IRS was set to reject tax returns if filers failed to check a box indicating that they would have health insurance coverage for a full year. This would have prodded individuals without health insurance to sign up for it. After the president took office, however, the IRS reversed course and allowed returns to be accepted for processing even if the relevant box is not checked. I'm not sure what they're talking about with the box there. I've always had to check a box that said which months I had health insurance, not that I had it. So it was like 12 boxes you had to check. And you had to provide how much you paid. Also, you wanted to provide that because it was a tax deduction. The refusal to make cost-sharing reduction payments directly harms plaintiffs and their residents. Failure to fund CSRs will lead to increased insurance premiums, insurer withdrawals, etc. I think we've read that argument about 6 times now, so I'm going to skip that. But basically the danger is that you're going to leave the sick people with insurance, which means the insurance is going to have to cover only the highest costs, which means that all costs will go up for those people enrolled, and then the only people that will be left are the sick. The healthy people will get the heck out of there because I can't afford to spend $16,000 a year on insurance or anything even close to that, and then we'll just. We'll go back to the old system where when you got sick, you walked into the emergency room and then you walked out healthy or at least treated, and then you didn't pay your bill, and then you declared bankruptcy if they came after you and you couldn't afford it. These are not good solutions, and this whole insurance marketplace, I'm going to argue without any statistics. I'm sorry, I don't normally do that, but I'm going to argue costs less than the old system of having people die and having people go to the emergency room for basic health care and having people be unstable because they can't get treated and can't get well for normal ailments. They have to wait till ailments become emergencies, basically. And they don't have enough money if they do have insurance because the insurance is unaffordable. I don't know that there's any returning to the days when insurance cost next to nothing. I don't think those days were really as good as some people think. Those were the days when people with pre-existing conditions didn't get insurance, when people who couldn't afford insurance just walked into the emergency room. Like the only reason insurance was cheap back then was because there were very few people on it, and it was considered a luxury to have it through your work. Anyway. The loss of insurance purchasers will have destabilizing effect. Fewer insurers will lead to more or less affordable coverage choices. Even in counties where insurers continue to offer plans, the loss of some insurers will lead to more uninsured. Congress, even if eventually Congress appropriated funds, it is unlikely to do so before insurers have made critical choices. They're making the irreparable damages argument for their injunction now. The Secretary's action will create annual uncertainty concerning whether subsidy payments will be made. So in other words, this constant terrorism of these threats will definitely destabilize lots of things. And I honestly can't see how this is good for anybody. This is the only people this is good for are parties who are interested in the results of this. So what are the results? More people off of public insurance and onto private insurance, insurance that's not offered through the exchanges. I see people investing in the stock market, and they invest in the right stocks or short or hold the right stocks, and they'll be able to profit from it. So this all seems just like a power or cash grab and a screw you to a political party. And I don't know that the president who is charged with faithfully executing the laws is really doing a faithful execution of the laws by trying to bring politics into the healthcare, the execution of the healthcare law. If the act is that bad, and they're saying that it's that bad, like there's no shortage of rhetoric from the administration that the ACA is that bad. So overturn it. Fix it. Pass a law that fixes it. It should be fine. It should be easy to do if you've got a Republican majority in the House and a Republican majority in the Senate and a Republican president. You should have no problem passing a law that fixes what you see are the problems. Except that you haven't been able to, because I haven't seen you doing a genuine, sincere job of trying to fix things. I've just seen stuff that really doesn't make any sense. If it doesn't seem to be governance, it seems to be turmoil. It seems to be that anyone who needs to benefit from these things, just F you. It doesn't seem to be any. Brandon, have you heard anything from the administration about how much they care about the people who are receiving these subsidies?
Not a whole lot.
I haven't heard like one thing from them that says we really, really think that this is going to help handicapped people or poor people, and here's why. I don't don't see. They say it. They say it's going to help, but they don't say how or why. I mean, here we've got an entire document of how and why it's going to hurt. I would like to see the administration's response to this, so I'm looking forward to that. So here we go. First claim for relief. Action not in accordance with the Administrative Procedure Act. Under the Administrative Procedure Act, courts must overturn agency action that is arbitrary, capricious, an abuse of discretion, and otherwise not in accordance of law, or that is in excess of his jurisdiction, authority, limitations, or short of statutory right. The departments are agencies. The Secretary's refusal is violation of that, and the payments should be made. Arbitrary and capricious, a second claim under the same Administrative Procedure Act. Violation of the Take Care Clause. The U.S. Constitution provides that the President must take care that the laws be faithfully executed. There we go. I thought that would be in here. By refusing to make the CSR reimbursement payments mandated by the ACA and its permanent appropriation, and taking other similar actions of the sort outlined above, the President and the Secretaries are deliberately seeking to undermine rather than faithfully execute the ACA. These actions violate the Take Care Clause. Fourth claim for relief, declaratory. An actual controversy presently exists between plaintiffs and the secretaries about whether the law as amended by the ACA provides a permanent appropriation. Plaintiffs are entitled to a declaration that the ACA authorizes and compels the secretaries to make the payments without further specific appropriations from Congress. They ask for a declaration that they have authority to make the payments, a declaration that their failure to make the payments is not in accordance with law, is arbitrary and capricious, and a violation of the Take Care Clause, to grant a temporary restraining order, preliminary injunction, and permanent injunction compelling them to make the payments, and award plaintiffs their costs of litigation, and any other such relief that this court deems appropriate. And then that's signed by all of the attorneys. Holy shit. Right? I mean, that's pretty, that's, and I agree. I happen to agree with this. There is no legal basis. Let's look at this for just one real quick sec. We've got a federalist government, right? So we've got a government that's established by a federal constitution and governs over the several states who maintain sovereignty and maintain rights. And we only grant to the federal government those rights that are enumerated in the Constitution and nothing more. So we have clauses that establish a judicial branch. We have clauses that establish a legislative branch, Congress, and laws that establish what those powers of those branches are. And we have laws that establish what the powers of the executive branch are. Now, there are three branches of government: judicial, legislative, and executive. The judicial is the courts. The courts are charged with adjudicating how laws have been enacted or how laws are being prosecuted or used. You have the legislative branch, which is charged with creating the laws, literally writing them and presenting them for vote and for signature by the president. And you have the president, the presidential administration, which is charged with executing the laws. Well, so what falls under executing the laws? Excuse me. Executing the laws is not making the laws, is not writing the laws. Certainly, the president or his staff or administration can physically write the words onto paper, but the president can't make that law. They can present it to Congress. Congress can decide to vote on it independently, and then they can promote the bicamerally voted legislation to the president for signing, called presentment. This is called bicameralism and presentment. The president does not have the ability to just willy-nilly make laws. Rather, proclamations and executive orders are his or her statement that they are going to execute the laws in a certain way, and that others, including their own administration, should act in accordance with that new order. It is not an outright decree, and the president cannot just go ahead and make anything into an executive order. And so that's what this is basically all about. The president has said that he and his political party disagree. And so instead of going through the process that we've all agreed to, remember, we aren't here by choice. I wasn't born by choice. No one asked me to be here. No one asked me for my consent, and I did not sign a constitution. So how in the world do these laws apply to me? Well, they apply because that's what we call the social contract. I'm not going to say that that's just because, though. The social contract is one of those things that we all agree to implicitly, and no one even really defines what the social contract is. Like, no one tells you what is in your social contract. You have to go and figure that out by reading and understanding the Constitution and reading and understanding society around you and figuring out what is it that's expected of you. The alternative is anarchy, and the alternative is every man for himself, and we kill each other, whenever we feel like it, without really any recourse, and people can form groups, and you might have the people who have the guns and the power might rule over the people who don't, or the people who have the money might pay for the people who have the guns and the power, and everybody rule over everybody who doesn't. And our country feels a little bit like this now, but we actually aren't there yet. We still do have the three branches of government. We have the checks and balances. We have a whole bunch of people like me and others who are way smarter and more powerful than me, who are very interested in keeping this dream alive. And so when someone does something that I would say is unilateral, is outside the bounds of their power, I like the Latin term ultra vires. Ultra V-I-R-E-S, ultra vires, 2 words. And it means outside the bounds of your power, outside the bounds of your authority. That the courts can step in and check the president's authority. So in this case, I think this is about as not in accordance with law, about as arbitrary and capricious, and about as bad faith as you can possibly get. I don't see a way that this could possibly be challenged successfully by the presidential administration. And it seems to me that this is just more political grandstanding from a party that is making less and less sense. It certainly makes sense that the party doesn't like the Affordable Care Act, and they want to do away with it any way that they can. However, making laws that are patently illegal, that are on their face illegal, and doing things that are not in accordance with your oaths, I don't see how those people can live with themselves, how they can sleep at night, and why so many people accept that behavior. It would be one thing if a political party was coming to the table offering their own solution. Instead, this just seems to be, let's erase regulation and let the chips fall where they may. And the whole reason we had these regulations and acts in the first place was because when the chips fell where they may, one of my friends couldn't get a lung transplant because she couldn't get insurance because she had a pre-existing condition of needing a lung transplant. It was dumb, and she was so relieved in 2000. Actually, it was before 2014, I believe, because there was a pre-existing condition thing that started before that, I think, and she was able to get results as soon as the law went into effect, and she's now healthy, and she's a comedian. She loves to make people laugh. I mean, like, what the heck does our presidential administration have against a person who's poor because they're always sick because they need a lung transplant, and all they really want to go do is go out there and make people laugh and make the world a better place, and they want to work and they want to pay taxes? I don't see how either political party has a problem with her wanting to live the American dream. And I don't see how providing health care to her is somehow such a burden that they can't provide even this what's relatively small amount of money to provide health insurance to these people who need it. I would want it for my mom. I'd want it for your mom. I'd want it for your sister, for your dad, for your brother, for your grandma. I'd want you to have it. Why wouldn't you, metaphorically you, why wouldn't you want me to have it? Why wouldn't you want my friend with the lung transplant to have it? I don't get it. It's I'm sorry. I'm sorry if I'm getting on my political soapbox, but this has crossed a couple lines for me, and I really don't think that this administration cares about. I really think that they put certain people, and it's not even black people or Hispanic. I think they just put like lesser people in a compartment in their mind, and those are just animals to be dealt with as little as possible and left to live out whatever lives they have while we do our own thing over here as a separate class of people. I don't even know how to define it. It's not elites. It's not the rich. It's not the poor. It's an us versus them mentality, and I'm not even sure who the us and who the them is. I know that I'm in the them. I'm not with the us who have the power and the money and all that. I'm with the them, but it's hard to define, isn't it? It's really, really hard to say, oh yeah, I like that. Better red than dead. I'd rather owe money than be dead. That's an interesting one. I don't understand what the divisiveness is in 2017. If anything, I thought after 9/11 we wanted to come together as a country and make it better for all of us. Instead, it seems like a good portion of the country wants to make it as bad as possible because at least that upsets the status quo. And I kind of get that. I can't say that I would have voted for this presidential administration, especially not knowing now what we know, that the upset and the turmoil and the behavior would be this destabilizing. And when you have this kind of destabilization, there's only a handful of groups that benefit. And unfortunately, conspiracy theorist Len is going to point back to that testimony we went over in Congress. Was that Bill Bradley? What was his name? Brandon, can you help me figure that one out? The guy that testified in Congress about how Putin is now the richest man in the world, controls half the corrupt money in Congress. Wow. Holy shit, there was a Freudian slip for you. In Russia. Whew! Somebody clip that.
That sounded correct, actually. Bill Cosby?
Bill Bradley?
Bradley, there you go.
Bill Cosby. Whoops. Yeah, I'll find it. Somebody remind me who that was. Bill Brower. Thank you. Bill Brower. His name was Bill Brower. He was an investor, financier, who was studying corrupt money in Russia because he was losing a lot of his own money to corruption, millions upon billions of dollars. So then he confronted Putin, who investigated by capturing the richest oligarch in Russia and throwing him in jail. The trial was literally the guy in a cage in the middle of a courtroom. Russian courts have a 99% conviction rate. So President Putin then turned to the remaining ruling oligarchs of Russia and said, I want half of the corrupt money. And I'm sure he said it more eloquently. And it was Bill Browder's testimony to Congress that Putin is now the richest man in the world, controlling more than half of the corrupt money in Russia and worldwide. Now, I'm going to let Robert Mueller and all that do their investigation and tell me whether President Trump or his administration are involved in anything illegal. But it occurs to me that all of this is happening at a very similar time, and that there should be a really, really healthy dose of skepticism added to any conversation about the Trump administration's motivations, because there has obviously been contact with Russia, and Putin is a very rich man, and Trump is a very rich man, and they would definitely exist in circles that would be able to communicate with one another. So again, I'm not making any conclusions or making any political statements. I am looking forward to hearing whether or not an investigation has revealed anything. But there definitely seems to be all the hallmarks here, all of the signs and symptoms of something fishy going on. And then you have more destabilizing behavior like this ACA executive order. So all I'm asking for is for some call for moderation and some sense and some calming down, maybe a little less hyperbole. The South Park episode about if you are a president of the United States, please put down your mobile device. I think that's a great public service announcement, and honestly, that is just that keeps ringing in my head as a really funny truism that I just can't get enough of.
I think that's fair criticism, honestly.
So I will get off my political soapbox. I realize I have probably offended several of you. I didn't mean to. I just want to have a conversation about it. Someone is more than welcome to explain to me how the Republican political party really does have my best interests at heart, and I really should change my vote to something in favor of them next time. But I'm not seeing it. All this does is reinforce how much I need to fight against people who treat others like this. It reinforces how much I need to present a moderate and meritorious argument here and other places to explain why we can't think like this, why we can't just go ahead and shut down people's health care and they'll deal with it somehow. There's a reason why a society, remember about that social contract that we said I wasn't here by consent and I've agreed to work by the social contract. Part of that social contract is that there is a government, that there is governance, and that there is some kind of actual efficiency to it, that it actually works. If we just took apart the government and there was no more government, then what's the point of me paying my taxes? And why am I giving them any money if all they're doing with it is going golfing all the time? And meanwhile, they can't even spend the same amount of money that they're going golfing to alert people and inform people about their health insurance. So I just don't see this as being a fair system. I didn't even expect it to be a fair system. I just expected it to be somewhat focused on governance instead of focused on marketing and politics. Think of the politics as marketing. You're trying to sway people to a side. You're paying money in advertising to sway them to a side. Now, we have cases like Citizens United that say that you're allowed to contribute and spend nearly unlimited amounts of money on politics. That overlooks a lot of things. That overlooks that now you've made it easy for people who have money to have more speech than people who do not have money. And you're saying that the voices of the poor are literally worth less than the voices of the rich. And so I disagree with that. I disagree with Citizens United, and therefore it's easy for me to be on a more moderate side and thinking that we do have to spend money on government. We do have to have some socialistic policies like car insurance, like health insurance. Those are socialistic policies. We spread the costs around from each according to to each according to their needs and from each according to their abilities, which is literally socialism. I'm not saying that I need to have this policy government-wide where if my neighbor gets a Lamborghini, I get a Lamborghini. That's not what I'm talking about. I'm talking about the basic health services that people need to survive, and that surviving will lead to their prosperity. Are there people who just want to sit around and be leeches off of society? Yes. We can certainly enact things to prevent that too. Have I seen a lot of people who want to be more than a leech off of society and can't because they are injured or damaged or ill in some way and need to get healthy or need to have stability? Yes, and I've even been that person. So I feel I have a dog in this fight. I've even been that person who needed help in order to get back to this place. And I needed to, by some people's definitions, leech off the system or be lazy or whatever, according to my father, while I recovered from an illness. And so why someone has to come along and say that you're not allowed to recover from an illness because that's laziness, or why you're not allowed to be ill in the first place because that's leeching off of the government, I think those are really derogatory things and really overlook the humanity of the people on the other end of that argument. So I really hope that that is just a hyperbolic thing that some people say, and that most of us really do agree that humans deserve to live, and while they don't necessarily deserve everything to be handed to them, they at least deserve to have the stability provided by their government to have a chance at or have a meaningful opportunity to advance their lives, careers, be a productive member of society, pay more taxes, because the government worked with them instead of against them. That's just my soapbox. I said I was going to get off of it like 5 minutes ago, so thank you for not crucifying me for that. I will stop. And that's all I have to say about that.
Question time?
Question time.
My number one question, I may be putting the cart before the horse because you may be planning this down the road, but we discussed yesterday that you may have received something in the post.
Oh, yes, I almost forgot. I did. I think his name is Dreadnought. Let me...
Yeah, Dread_Not, I believe.
Dread_Not has sent me a box. And let's put this full screen. And, I'll make the dogs a little smaller because I would like you to see... Well, okay. We'll not make the dogs that small. So I got a box. And in this box, which I hear comes from Minnesota, I got some apples. Here are some Minnesota apples, and they are very good. They did not spoil. And they are very good. They just rolled off my desk. Let's try not to do that again. There we go. Dreadnought sent Trump hair cotton candy. This is yellowish cotton candy. Cotton candy. Wow. Cotton candy that looks like Donald Trump's hair. Very nice. I have not seen Japanese rice balls in a very long time, but here are Japanese sugary, cakey rice balls. I'll try those at some point. I don't think I've had those in 26 years. For anyone who's going fishing, here are some mealworm snacks for your fish. Yes, I realize those are meant for human consumption. I don't even want to think about that. Here are some green tea Kit Kats. Yes, they are literally green Kit Kats. I haven't tried these yet, but I'm looking forward to trying those.
Sorry, I just love the name of the mealworms, Larvettes.
Larvettes. Here is a Best Bros chocolate bar with what looks like Trump and Pence on it. I don't even know that I want to open this. It's just so perfect the way it is. And then 2 boxes of Jaffa cakes. Not lava cakes, Jaffa cakes. Jaffa cakes. Orange and cherry, it looks like. I've never had these, and I'm told that they are wonderful. So I am looking forward to sampling all of these over the next coming days.
Leonard, I'm told that's not Mike Pence. That is Vladimir Putin.
Okay. Vladimir Putin is bald, though, isn't he?
Mostly.
Okay, so that's supposed to be Putin. Putin, as somebody says. Yeah, let's compare him to duck liver. Putin. Isn't that what Putin is, duck liver? I tried it once, never have to have it again. Not my thing. Dog video. Back to dog video.
Boy.
Okay, so thank you for getting through that fairly politically charged thing without... Okay, so he isn't bald, so it could be Putin. Okay.
Yeah, he's got like the little tuft, you know.
So that was interesting. I like that. I wondered what arguments they were going to make, and I thought that they were going to make the faithfully execute the laws argument, which I did not know was called the take care clause. So today even I learned.
All right. You want to get into real questions or?
Yeah, let's get into real questions, and then we'll take the stream out. I got to go in about 20 minutes.
Alrighty, we only have a few. Well, we have a bunch of questions, but I've highlighted a few here. First one comes from AB. Question is the case copyright small claims court designed for individual claims, e.g. Imagos, or is it designed to streamline a billion claims some might make? So it's
both.
Okay.
It establishes a copyright small claims court for everybody, and that means that Disney or HBO or even Malibu Media would be able to use that system instead of the court system. So yes, I would expect that you would see an increase in copyright litigation through that system after that system was established. Is that a good thing or not depends on your perspective. If you are a serial infringer who thinks that information should be free, maybe you don't want to have an easier time for people to sue you in a copyright small claims court. If you are a content creator, you probably want the ability to skip the $400 filing fee and the expensive retainer for an attorney and a formal court process in order to have something more like an arbitration, where you simply present evidence via email from your desk and testimony over the phone, and then an adjudication is made, and if something needs to happen from there, you move on, but hopefully that adjudication is where you stop. So it's a double-edged sword like everything else. It's a good thing for some and a bad thing for others. It's a bad thing if you are a person who would be a target of this sort of copyright litigation. And how would you know that? I don't know, because we haven't seen who would, like, no one has announced, we plan on suing people who infringe on photography more often when we get this, or we plan on suing people who commit YouTube copyright infringement more often. You really just have to assume that's going to happen. You're going to see an increase in all that litigation. Next question.
Alrighty, from Brian we have, in your opinion, would a software glitch, i.e. missing no from Pokemon, be a copyrighted work? So
missing what from Pokemon?
Glitch in Pokemon that can happen sometimes if you glitch a certain bite into a spot it's not supposed to be. You can encounter a certain Pokemon. Basically, they created art without intending to.
Sure.
So do you think
whether you intended to or not doesn't have anything to do with copyright. If you fix something in a tangible medium of expression, that's copyrighted. Fix something creative. So there has to be creativity. You're going to have to argue that your inputs were creative inputs. I think it's a pretty easy argument to make that your playing of a video game is not just a mere pressing of a play button and then watching. You are making decisions, and those decisions do rise to a level of creativity. Now, you take that one step further and you're intentionally trying to glitch the game to achieve something creative. That's probably transformative, and that's probably a new copyrighted work. However, if what you've done is a speed run instead, and you're more performing the work and you haven't created a piece of art, then that's not transformative and not a fair use and not a new copyrighted work, and you're just performing the work. These distinctions, though, haven't really been tested too much in court, and I think someone would have to take it to court to have a judge decide what level of let's play versus speed run versus glitch art versus actually creating your own. So what if somebody creates a video game that is like a choose your own adventure but it's like a procedure, like these procedural. Here's a good one: procedural generated video games. They generate something procedurally, and then you choose how you react to it and what storyline you go down and all that. Do you own something in your choices? And when you play that game on YouTube streaming or Twitch streaming, do you really own that copyright? And the opposing party, the creator of the original work, really only has a right to make you either license or not license the parts that aren't your new copyright? And what are those parts? It's a very complicated question. It's a very good question. I don't know that it has a clear answer. Next question.
Alrighty, from Claymo. Is there any update on the John Oliver case?
I have not looked. Somebody, Brandon, let's write that down. Let's assign that to one of our new staff members who are writing stories now. Maybe Moxie would like to do something like that, or maybe we can ask some other person, or maybe you'd like to do that. Somebody check up on the John Oliver case. If you need documents, let me know. I'll get you documents. Also, the Purple Mattress case needs an update. I don't have an update on that one either. Next question.
Next question comes from Chris from England. Not New England, rather Old England. That's what he wrote in the person box.
England.
He says he's over in the UK and he keeps hearing the phrase well-regulated militia, and he's wondering if that has a legal definition.
It is up for debate. Oh, I'm sorry about this with the video. Here, you know what? Let me skip this part of the dog video, because it's doing the thing again. So well-regulated militia has been read into law. I am not a First Amendment attorney, but well-regulated militia has been read into law to mean that states can regulate for safety and security the bearing of firearms. And so it's not a toothless clause, but the other half of that says that the right of the people to keep and bear arms shall not be infringed. So the question and the debates are always, how much does the well-regulated militia part apply to the individual's right to keep and bear arms? So far, I believe there has been a recent ruling in the DC Circuit Court of Appeals that there has to be a meaningful Second Amendment right. You cannot regulate the Second Amendment out of existence by saying that only certain people get to have permits and that the police issue the permits and get to make the decision of who gets permits. No. Remember we said there was a legislative and executive branch? The police are under the executive branch. And so they are charged with executing the laws, not making them. So if the law says you have a Second Amendment right, then that means that the police can't turn around and say, well, it says you have it, but we're not going to allow you to have it. No. They have to faithfully execute the laws. They have to allow you to have your Second Amendment right while also maintaining safety and security. So they have to balance those two interests. And what you see are a lot of court cases where laws are made attacking those rights, regulating something. Let's say in the assault weapons ban, or in the DC Circuit case, it was an outright ban on concealed carry or ownership of pistols whatsoever. So instead now the DC police and law enforcement authorities have to go take this court's opinion, and they have to figure out how to implement it, how to faithfully execute now the law and the court's opinion, because they apparently weren't doing that before. So what it means is definitely up for debate. I am not a Second Amendment expert, but I'm quickly becoming accustomed to it because it's obviously been in the news. I'm also a competitive shooter, and so I'm very concerned about keeping my rights, while also being concerned about maintaining everyone's safety, including my own. Guns are not a panacea. They are not a silver bullet, no pun intended. They are not a single solution to all problems. In fact, they're not even a solution to most problems. Having the crowd in Las Vegas would not have solved, the crowd in Las Vegas armed would not have solved the problem of Stephen Paddock shooting down on them. Having a gun in a crowded mall is probably not going to solve the problem of a mass shooter either, until someone can separate the shooter from others in such a way that a shot can be taken. These are all tremendously difficult strategic decisions that have to be made in the moment. And there is lots and lots of room for discussing when and how and who should make those decisions, because I do not trust the average American citizen to know when it's good or when it's wrong or when it's right to pull a gun and shoot somebody, especially around me or in an enclosed area where it might hurt my hearing, or just in general out in the open where it could hit somebody. So there's lots of room for this. So it's not a simple argument to have.
I saw some feedback in the chat from Chris. When you said the executive branch is charged with executing the law, it clicked in his head, it looks like, and he kind of started to understand. So that's good.
Okay.
You answered his question.
Yeah, so some of us that are reacting like the president is out of his mind are reacting so because he clearly doesn't understand what his role in government is, or understand the oath of office that he took. These aren't empty things, so it's weird. Let me say personally real quick here. It's even weirder for me. My father's the kind of person who would hold me accountable for every little thing, and then goes off and votes for the Donald Trump administration and gives him a pass on every lie that he tells and every falsity that he furthers, and every action he takes against people that's illegitimate. So it's I feel like this is the president of hypocrisy, basically. Even if you are or were a supporter of the administration, there's obviously been some things that they've done that are not in accordance with what they said to their own supporters. And so it's just a strange time to live for me. I really just want a moderate government with appropriate regulations that allows the free market to grow and flourish, that promotes hard work and promotes innovation. And when people work hard and innovate, well, first off, let's back up. Can they work hard and innovate because they're healthy? Yes, in my government, you'd be able to work hard and innovate because you would have the government's support. Disabled people would be supported, as they are now, with reasonable accommodations for their disabilities, and ill people would be accommodated with reasonable accommodations, treatment for their illness. And then those people would be promoted to go on and innovate and work hard and rise above the level at which you're too accustomed, which is the freaking American dream, isn't it? To be able to work hard and accomplish and achieve the stability, a life, liberty, and pursuit of happiness. These things are the core of American values. So someone please tell me how President Trump withholding required payments for the ACA subsidies furthers Americans' pursuit of life, liberty, and happiness. I don't see any connection whatsoever, and it really bothers me. So, next question.
Alrighty. Next up we have from KW. What professions would you advise to potential college students who are looking for a robot-proof career path that they could work safely for the next 30 plus years?
Making robots?
That was a good one.
No. Okay, so artificial intelligence is a really good career to go into. I would highly recommend that anybody even take the artificial intelligence course that's offered by Stanford or Berkeley, I think, in one of their free online courses. Now, that said, it is a difficult course, and yours truly does not have the mental prowess to understand everything in that course, and I dropped out of it. I would have to study for many hours to understand AI. However, Evil Ash is saying that there are not enough job openings, So maybe what I'm trying to say is there's opportunity for innovation in AI, and not maybe Abel is trying to say there's not enough job openings. But then again, I also think that's going to be a growing field. I don't think that's going to be a shrinking field. Likewise, maintenance of automation technologies, IT staff, programmers, hardware engineers and technicians, those are going to be in demand. Creative pursuits, yours truly has read many, many times that although you can't just go and create anything, there's going to be much higher demand for creative things that robots can't do, because those are the things that make humanity, and so they're going to be more valuable as people come to recognize that there is value in the unique and creative, that while automation and robotics are valuable, that they're not yet able to be that level of creative and innovative. It might reach it at some point. I honestly think we are going to see a robot revolution at some point. Not in my lifetime, but I honestly think that at some point there will be enough power that an AI will reach human levels, and we're going to have a revolution of rights. What makes a person a person? Is it the fact that they're a person, or is it their consciousness? And what happens when another being reaches that level of consciousness? What happens if we discover in the future that dolphins or dogs are that level of consciousness? And do we start having to give them similar human rights as we have? I'm not saying dogs are conscious like that now, but we are finding that dogs have a level of consciousness that approaches about a 6 to 8 year old human child. And while that's not necessarily enough to give them unlimited rights to make their own decisions, I do think it is enough to acknowledge that they're not property that can be mistreated at will, and that we have to give them some kind of basic right to dignity, to peace, to a lack of unneeded suffering and pain. And that's how I treat my dogs. Honestly, I treat them like people. I treat them like little kids, and they get my respect, and they're treated with dignity, and they're allowed on the bed. And you know what? They give that love back 100 times, and they're wonderful. And I honestly don't see how other humans don't see this about other humans, that while it's not an overnight process, if we simply treated each other with more dignity and respect, and I understand that those are buzzwords and you can read into them with different agendas, but if we just treated people genuinely and more sincerely, and we listened to their needs and saw through the bullshit — I understand there's lots of bullshit, but if we collectively decided to do this, the world would be a better place, and there would be more and faster innovation, and we'd be going to Mars earlier, and more people, and there'd be more people would be able to travel and see the world, and help people who couldn't see the world and all that, and more innovation in medical. I'm getting on my soapbox again, but you get it. I just see it as a good thing to promote humanity, as opposed to scrimping and scrounging to pinch every penny away from innovation in the name of destroying or subverting those lazy, poor, and sick people who are leeching off of the rich and powerful. Socialist utopia, a little bit. I don't see it as socialist, though, to promote innovation and hard work. So if I work hard or I innovate, and I should be allowed to earn more money and get my Lamborghini and get my nice house and live like Notch in the most expensive house in Beverly Hills. He deserves it, doesn't he? He made Minecraft. How is that socialist? Not at all. What's socialist is when I say that I think that people like Captain Yosho over here should be allowed to have health insurance subsidized by the government so that he can stay healthy while he is growing up and learning and becoming the person who will innovate and support. If Brandon was sick or otherwise unable to work because his life was so unstable, he wouldn't be here helping me with this channel, and et cetera, et cetera, et cetera. We need support for innovation. Innovation is not something that just happens. It's not a spark that just spontaneously ignites. There's years and years of investment and preparation into a person before they have that $1 million idea. Even Bill Gates went to school first. He did drop out of college, but even Bill Gates and all of his wonderful ideas still had the support of an education system, and he was able to compare notes and see that he was a little bit ahead of his peers and come up with some ideas and push them. And I'm sure that he had support in more than one way, but imagine if you don't have financial support from parents or independent wealth or automatically have a good job. How do you get it if you are sick or disabled or just already have no experience at a job in a market that is deliberately against people who are sick or poor or don't have jobs? I don't see it. So there needs to be a baseline. There needs to be something that helps you, like having health insurance, so you can be healthy and stable while you are learning to innovate, work hard, be more of an American citizen. At the same time, do I see an obvious avenue for people to be leechers and not contribute and not grow and not learn? Yes. That's why we have to promote those things. There has to be incentives. The economic power of the incentive is the way that people are motivated by things. It literally studies how people are motivated. So there are lots and lots and lots of opportunities to discuss the details of what I'm talking about without jumping to conclusions that I am talking about pure socialism. I am not talking about a socialist utopia. I actually don't think that socialism works that way, and I don't think that if you created a socialist utopia, it would work any different than forced Marxism in the form of communism has worked. We even see the problems China has now with censorship and a huge difference between poor and rich and all that. But at the same time, China is not necessarily doing the same kind of forced Marxism that Russia did or others have done. Instead, they're doing a kind of socialistic capitalism, and they're trying to promote some innovation while also socializing many things. So it's hard to just put a label on it. It is a very difficult question, and honestly, there would have to be a lot of discussion on it. So anyway, social democracy is a good term, I think. Communism it's interesting that communism is such a bad word, yet I haven't seen a strong backlash against the Russian conflict of interest with the presidential administration. So either there's nothing going on there, or there's a lot of hypocrisy where people think that communism's bad, but Putin is okay. Trust me, Putin is no different than anyone from old world Russia. Anyway, so that's what I have to say about that. Brandon, do we have a next question?
We do. From Pilsabab, I think. You have previously said that the courts have broad powers when it comes to contempt of court. What would be the range of those powers, and do you know any good examples? We have had this question asked a few times, but I think it's still good to go over for people.
Yeah. The court's contempt powers are broad, and although they are also subject to court review by a different court, you find that the court's contempt powers are unlimited. Virtually unlimited is the way the court would say it. Now, does that mean that the court can arbitrarily and capriciously throw you in jail for nothing? No. It means that the court can throw you in jail, though, if you choose not to give up the password for your mobile device when the court believes that that all of your rights have been preserved. and this is the case out of the Ninth Circuit that we were just talking about, where Nolan is his what's his name? Dolan. No, wait, hang on a sec. Nosel in the Ninth Circuit, United States versus Nosel, and Nosel versus United States. It was a CFAA case where they tried to compel him to give up his password, and he didn't want to give up his password. So instead of giving up his password, the court held him in contempt and said, you are going to jail for not giving up your password. You are allowed to get yourself out of jail at any time by just giving up your password. And so that person has been in jail or was in jail for a very long time. And the whole point of that exercise was so they didn't have to provide a password that they think unlocks a hard drive that has child pornography on it. And the reason why it wasn't a violation of that person's testimonial rights is because the court already knew what was on the hard drives. There were several witnesses and other evidence that had testified that the hard drives contained child pornography. And so having him give up his passwords was more confirmation than testimonial, according to those courts. And I believe it was ruled once, and then he appealed, and then the appeal ruling denied him as well. That yes, the government can compel you in certain circumstances to give up your password, and if not, if you don't give it up, that is within the contempt powers to throw you in jail and to hold you there until you do give up your password. So be careful about that stuff. The contempt powers, like I said, are virtually unlimited. The court can construct just about any remedy, including jail time, including fines, and sometimes there are some things in between. Anyway, next question.
Next question is from Skullmeat. Interesting name. I am a freelance IT PC repair. What are my legal options if my client refuses to pay or I have a dispute with him? How can I protect myself?
Well, you'd want to have an attorney draw up a contract that's favorable to you and that has clauses in it that your client would want to avoid. Usually we call these liquidated damages clauses. You're not allowed to punish somebody in a contract, but you are allowed liquidated damages. So instead of saying, if I break your contract, you get to sue me for the money that you can prove, you put a liquidated damages clause in there that says that if you violate this contract, you owe me $5,000. You have to put the basis in there, or at least you have to have a basis for why the $5,000 is close to what you think damages would be, and that the parties agree that they think that that's what the damages would be. But then when they violate, you get to point to the liquidated damages clause. You get to say they already owe you $5,000 or whatever the amount is. And then when you're going to court on proving the liquidated damages clause and not proving the contract violation beyond the actual violation. You don't have to prove the actual damages. The trouble with this is that the liquidated damages clause does have to be tailored to the amount of damages. So it doesn't have to be exact, but it has to be thoughtfully, reasonably well thought out. So definitely talk to your own attorney, because I can't help you with that here on stream or from across the country or wherever you are. Unless you're in Pennsylvania, I couldn't help you write that. So talk to your attorney and ask him to help you write a more favorable service contract. Next question.
One more question from somebody who has told me that their name is pronounced Ashin. I believe I said it right.
Okay.
This one is a bit of a vague question, but what do you think about the Epic Games versus Fortnite cheaters court case highlighted by Sid Alpha? Epic Games alleged that...
I'll be covering that.
Okay.
Excuse me. I didn't have time to cover it by this morning, but I will be covering that this week. So expect to hang on. Sorry, wanted to take care of that real quick. I will be covering that this week, and I haven't read through the complaint or anything yet, but I do have it, and will be covering all that. I think it's a very reasonable thing to do to sue cheaters for violating the terms of service, both in spirit and actual black letter terms of service. It's Yeah, that's gaining an unfair advantage is probably both doing damage to their brand and some kind of unjust enrichment or something. I'm going to assume that they sued people who create or promote cheating, not just individual cheaters. But we'll see. I haven't looked at it yet.
All right, that's all I have. There's a couple more questions, but obviously, some of them are in depth, and
So I'm going to end the stream there. I have to go to a meeting that I'm attending, and I'll be back. But normally I would have a stream, a second stream. We would stream video games, and I would talk to a bunch of people on my Discord channel. I actually think I'm going to still join the Discord after this, so give me like 10-15 minutes and I'll be on Discord to chat with everybody as I drive to my destination. But I'm not going to be streaming video games after this. So thank you all for joining me. This was another amazing stream. I love having all of you here to discuss copyright law and other law, and to have you hear me and give me feedback on my weird political rants that I'm going on that I think are moderate and I hope are moderate. But I'm a human, so I'm capable of being biased or swayed or have my barometer off just as much as anybody else. So that's what you guys are for. I want to have a great community here, and we got to live life together, right? We're all in this together. So let's just keep on keeping on our journey on Spaceship Earth as we travel through the stars and travel through our lives. Is there anything else, Brandon, that you would like to add before I close?
No, there's not. I'm tired.
All right, Brandon, you go get some sleep. Thank you very much for joining me. I would like to thank my Patreon supporters. You are all wonderful people who are giving your hard-earned money to make this channel possible and make it make my life more stable, make some more space in my life. You have definitely, I've gotten rid of 4 cases this week, and next week is pretty much clear. So I'm going to try and make videos every day this next week. I know I promised a few more videos last week, but I at least got one out, and this next week will be golden, I swear. So thank you so very much. Looking forward to all of that with all of you. Thank you to my $50 plus supporters, Joshua Meinzinger, John Steele, John Cripps, Nate Beck, Lydia Collinson, and Westin Lohne. You're all contributing at the $50 plus level, and I really, really appreciate that. All of my $5 plus supporters are scrolling on the LED panel behind me and are in the description of the video below, and there are a few hundred more $1 to $2 supporters out there as well, and many of you who contributed more than $5 but don't want your name revealed as well, or your handle or whatever. That's fine too. Thank you to all of you. You really do make this possible, and everything is continuing to advance. I will have some other announcements this week about some things that are happening, and I'm looking forward to that as well. I can't say anything now until I have some things set in stone. So I'm Leonard French, your favorite copyright attorney. Thank you for joining me. I'm going to leave the stream up for a moment while I go downstairs and grab the dogs who are outside, and then I'll put them on the stream for us for a few minutes before I go. So I'll be right back. Again, thank you for joining.
Hello, everyone. I'm Brandon. How's it going? I hope you had fun today. I had fun. And now we are just waiting for Leonard to come back. I'm from Chicago.
Yep, the Logitech webcam is dead. Okay, let's fix this.
Oh.
Nico. Nico. Hello, honey. How are you? Dog cam. Hello, my honey. Hello, how are you? Hello, honey. Can we get an Ilsa up here too? Ilsa. Ilsa. Oh, here she comes. No, over here. Good girl. Good girl. Good girl. Good girl. It's a competition. Okay, everybody. I gotta go. I'm already late for stuff.
Goodbye, Leonard.
Told somebody I'd be there a little bit earlier than I'm going to be, but it will have to be okay. Come on. Okay, so everyone, thank you very much for joining me. I'm Leonard French, your favorite copyright attorney, and I will see you in my next stream next week and in my next videos this week. So thank you all. I am signing off.